summarize our position on the proceedings of today in three parts. First is to commend the trial judge for delivering such a detailed, reasoned ruling on these interlocutory applications. As a lawyer myself and a student of the law, I must say that I was impressed. This enriches our jurisprudence and helps students of law to appreciate the law. It helps us to constructively agree and disagree or criticize. And so to that extent, I think this ruling contributes to the development of the laws of this country, and we commend the trial judge. The second has to do with our disagreements with many of the decisions the trial judge made. Now, you would realize that on the application by lawyers for the first accused, Honorable Atufo, for an order of mistrial and an order of inquiry to be made by the trial courts into issues of prosecutorial misconduct and professional misconduct on the part of the Attorney General, the trial judge played Pontius Pilate by declining jurisdiction. In other words, what the trial court said was that no law confers jurisdiction on the court. Neither does any rule of practice confer jurisdiction on the courts to make such orders. And therefore, the trial court directed Honorable Atufo and the affected parties to seek redress at the appropriate forum, which, in the opinion of the trial court, is the general legal counsel. Now, ordinarily, that should have been okay for us, because what that means is that the court has not determined whether or not the Attorney General is guilty of prosecutorial misconduct. Okay, what the court has basically done is to decline jurisdiction and say go to the right forum. But that for us raises serious issues of law, because number one, we know that per Article 140 of the 1992 Constitution, the High Court has jurisdiction in all matters, both civil and criminal, except in cases that the law has expressly taken away the jurisdiction of the courts. So that is the rule. The general rule is that in all civil and criminal matters by Article 140, the High Court, as a superior court, has jurisdiction unless a specific law has taken that jurisdiction away. We are saying that in this case, there is no law that takes away that general jurisdiction of the court relative to orders for mistrial and inquiry. Because you see, the court is there to do justice, and the court has a responsibility to ensure that its processes are not abused. And so where there are serious issues about abuse of the court processes, the court has the jurisdiction to deal with those matters under Article 140. And we don't know of any no law that takes away that power. Number two, assuming without admitting that there is no specific law that even confers that jurisdiction on the court, or that power on the court to make orders for mistrial and orders for inquiry in our jurisdiction. The point is simple. The common law is part of the laws of Ghana. If you check Article 11 of the 1982 Constitution on sources of law, the common law is part of the laws of this country. And that is why when our laws don't provide for certain issues, judges will always refer to decided cases outside the jurisdiction. They have persuasive authority. Now the point is that these applications were not even moved at the last agenda date. You would realize that when we came to court and her ladyship had the preliminary objection by lawyer Thaddeus Serwaa, lawyer for Mr. Jakpa, the judge said she was going to decide the cases on the affidavits. The judge did not even allow for the norm, which is for counsel to say, I'm moving this, I have this motion for so and so before the court. I move in terms of the motion paper, the supporting affidavits, and I exhibit, which is the norm, the usual thing that happens in court. And if there are issues of law, the court may, in exercise of its discretion, allow counsel to address the court on those issues of law. So the judge says, I don't know of any no law or practice that confers jurisdiction on me, and proceeds to make argument. Where did the judge get those arguments from? When you did not allow the lawyers to move the application, You did not allow the lawyers to even argue on whether or not they think that the High Court in Ghana has jurisdiction to make such orders. Where did she get the arguments from? So that for us is problematic, and we totally disagree with that. Now, apart from that, is the issue of weight. You know, the judge went on to comment on the audio recording of a telephone conversation between Mr. Gyamfi and the Attorney General. This is the audio recording we in the NDC put out through a press conference we organized. And the judge, in her ruling, says that she has listened to the tape.
10 times.
And in the tape, the Attorney General doesn't make certain statements, but rather it is Mr. Gyamfi who makes those statements about the Attorney General seeking to impress on him to implicate Atofalso. The judge says that the Attorney General never said that on the tape. The judge also says that the Attorney General never told Mr. Gyamfi to help him, and that on the tape, the Attorney General said he didn't need his help. Now, these are matters of fact that we think the trial judge got wrong. The judge was terribly wrong on them. And anybody can go and listen to the tape. Number one, if you listen to that tape, you will hear Gofredame telling Mr. Gyamfi that if you agree to this deal, that is on the tape. You will also hear Gofredame telling Mr. Gyamfi to testify his way, and that does not create any difficulty for Mr. Gyamfi. He says that about 3 times on the tape. You will also hear Mr. Dame saying that if you agree to this, what were they talking about there? They were talking about letters of credit, which is the main issue at stake in this trial. And the entire case of the Attorney General was built on those responses he was soliciting from Mr. Gyamfi. Very material to the issues for determination in court. And it is clear on the tape that Mr. Dame was seeking the help of Mr. Gyamfi. Either than that, why did Mr. Dame call Gyamfi in the first place? If he didn't need his help, he called him to give him lunch or dinner or breakfast. Or he called him to do what? He called him for a purpose. And the purpose was to get him to answer questions in a particular way. Is that not him seeking his help? Number one. Aside that, the trial judge also makes statements about, let me just refer to some of the notes I made, that the Attorney General did not utter certain words, okay? Words that Mr. Gyamfi uttered on the tape, that you have been meeting me in my cousin's house and you've been telling me to testify in this particular way, and if I do that, I will be dishonest and I'll be helping you to jail an innocent man. I'm paraphrasing, right? And the trial judge says those were words uttered by Mr. Gyamfi. But the trial judge forgets that was a conversation. When Mr. Gyamfi said that, did the Attorney General say, it is not true? I have never told you that. I have never met you in your cousin's house. I have never impressed on you to do the things you're saying. No. On the tape, the Attorney General is quiet. And you realize that at some point, the Attorney General even says that we are talking on phone and I don't know who is recording. If the things Mr. Gyamfi was saying were false, why didn't the Attorney General say so on the tape? So the judge cannot say, in our humble opinion, that for the mere fact that those words were uttered by Mr. Gyamfi, then it is not true that the Attorney General didn't do that. We are saying it is true that he did that in our opinion because the Attorney General did not deny. And you could see that the Attorney General was uncomfortable that Mr. Gyamfi was bringing out all those facts in that phone call and had to even say that, I don't know whether this is being recorded. So these are matters that we disagree with the court on. Number one, the issue about the judge saying, I don't have the power, no law or known practice confers jurisdiction on me to make these orders. We are saying that if he had allowed counsel to move the applications and at least hear them on those points of law, maybe the court's position on that would have been different, because we strongly think that the court has that general jurisdiction. But even aside that, common law allows that, because you see the contradiction. The judge says we are relying on decided cases outside the country, and for her to be able to rely on that to make an order for inquiry or mistrial, she needs to find local laws to support it. Yet you realize that when she was giving out her ruling on the issue of stay of proceedings based on prosecutorial misconduct, what were the cases? She cited 3 cases, all Canadian cases. So why do you in one breath say that I can only rely on decided cases in Ghana, or the law as stated clearly in our laws in Ghana? But when it comes to stay of proceedings, then you rely on decided cases in Canada. Clearly we disagree, right? That's the court decision we disagree, the lawyers will advise. But let me tell you the other good things about the ruling, which we agree with. What we agree with and commend the judge for was, number 1, to admit Exhibit CAF2, CAF2, which is the audio recording the NDC put out, which Mr. Jakpa annexed to, the Honorable Atoforsen annexed to a supplementary affidavit. That audio recording, they've been saying that it is doctored and all that. They couldn't say that it is doctored in court. They've been challenging its authenticity in the media. They couldn't say that in court. So it was 26 minutes. The Godfrey Dami himself, whose voice is on it, Mr. Godfrey Dami himself, whose voice is on it, could not swear an affidavit to dispute the tape. He had to shift responsibility to a principal state attorney who was not on the call to make denials. Now the court says, I have listened to you. There are exceptions to the rules of privacy under Article 18.2 and 12.2. Public interest, issues of crime. I am admitting that evidence. That is a heavy blow for Godfrey Dami, who has been trying to escape accountability and has been sponsoring his assigns and highlands like Nana D and Paul Adomotri to be saying in the media that the tape is doctored, it is not admissible and all that. Now that argument has fallen flat. They have eggs all over their faces. The tape has been admitted, and that is why the judge made copious reference to it in delivering this ruling. And you've seen the line of cross-examination. More tapes are coming up. More tapes are coming up. Then number 2, and that is the juice of this matter. That is what makes all of us happy about this matter, is that the trial judge says that it gives great discomfort for an Attorney General and Minister of Justice to be speaking to an accused person when he knows that he's not supposed to be speaking to the accused person in the first place, and to be speaking to an accused person who was a lawyer in the case against the ethics of the profession, including telling the accused person to lie and contrive a medical excuse duty to deceive the court. And the judge says these are serious issues of professional and prosecutorial misconduct, and that the appropriate forum can deal with that. We have taken a cue from that, and we know that the appropriate forum is not only the GLC. The GLC is one. We shall trigger that process at the right time. But we also know of Article 218 and the powers of Shraj. We know of the powers of Parliament under their powers to censure a minister, and we are going to be triggering all these things. There is no way that this dishonorable, crooked character called Godfrey Dami will get away with these unprofessional conducts and criminal conduct. There is no way. We want to make that clear, and the judge clearly, even though she denied jurisdiction, has given us a cue, and we know what to do. Aside that, the judge went on to say that Godfrey Dami should stay away. She is advising or directing, whatever word you use. An advice. An advice can lead to a direction. Strongly advise. Since Ghana became Ghana, from the days of attorney generals like Geoffrey Binki, have you ever heard the courts telling an attorney general that I'm strongly advising you to stay away from a case? The attorney general in whom all the prosecutorial powers of state are vested, being told by a judge that I strongly advise you, stay away. This is a shame. This is a shame of a disgrace of monumental proportions. And it justifies calls, not just by the NDC, but even by neutrals like Professor P.J. Tuya, neutrals like Mr. Insiasari, the former director of the Ghana School of Law, neutrals like Martin Pegu, who are calling for the resignation of this Attorney General, and people like my good friend Samson Ayenene calling for an inquiry into these matters. The judge, the court is scandalized, the court is embarrassed, the court is uncomfortable with the unprofessional conduct of this crooked Attorney General, and says stay away stay away. So we wait to see what Godfred Dami will do, whether Godfred Dami will heed to the advice of the courts or defy the advice of the courts. But even if he decides to defy, he will meet Jakpa in the box. And apart from meeting Jakpa in the box, his day of reckoning is coming. And I'm telling you, we will pursue this matter to its logical conclusion through the professional misconduct angle and also through the criminal angle, as we have already said. Thank you very much.